Welcome to the Landmark Chambers Property Law Nuts and Bolts Seminar Series. This is part 4. It's about service charges. I'm Tim Morshead and I'll be chairing this evening's session. But the hard work and the heavy lifting will be done by 3 of my colleagues who are all 3 property specialists, some of them with crossover practices, which is one of the things that you'll find distinctive about Landmark Chambers, if you haven't already. So let's start. We've got 3 talks this evening. The first is by Peter Sibley. Peter, I would say actually at the outset of all of these people who I've had the pleasure of getting to know over a few years, that I'm very glad that none of them was competing for a place in Chambers when I was starting at the law. Everybody coming to the bar these days seems so much more capable than I ever was, or indeed am, and I'm very grateful not to have to compete with them. But Peter, not least because he's a road bicyclist, and I used to do a bit of bicycling, but I was always quite slow. This chap, I think, is probably quite quick. Anyway, as well as being a bicyclist, he practices exclusively in property litigation, and he has quite recently, just last year, he was in a very large case, multi-million-pound case, by a tenant against a landlord in respect of repairing obligations, and also in a possession action relating to one of those super prime properties said to be worth about £70 million. So we're going to hear from Peter about contractual machinery and reasonableness.
Good evening, everyone. I will be speaking about contractual machinery and reasonableness in the context of service charges. Now, reasonableness is something that I think will be covered by my colleagues later. So in the true spirit of reasonableness, I will leave that to them. So my focus will be on contractual machinery. The starting point for any discussion on the contractual machinery in the context of service charges and the construction of a lease is the decision in Arnold and Britton, which, as some of you may know, featured none other than Landmark's own Timothy Morshead QC, as he was at the time. So I will be leaving any questions on that authority to Tim. The decision, I am sure you will all know very well. But given that service charge provisions are, of course, contractual terms, it is useful to remind oneself of the basic principles. In Arnold, the court rejected the submission that service charge clauses are to be construed restrictively. At paragraph 23, Lord Neuberger said, reference was made in argument to service charge clauses being construed restrictively. I am unconvinced by the notion that service charge clauses are to be subject to any special rule of interpretation, even if a landlord may have simpler remedies than a tenant to enforce service charge provisions. That is not relevant to the issue of how one interprets the contractual machinery for assessing the tenant's contribution. Lord Neuberger then went on to make several helpful observations. First, one must identify the intention of the parties by reference to what a reasonable person with all the background knowledge would understand, and that meaning is most obviously to be gleaned from the language of the provision. Second, focus on the surrounding circumstances or commercial sense should not be invoked to undervalue the importance of the language chosen by the parties. Third, the court should not actively seek ambiguities or a lack of clarity in order to justify departing from the natural meaning of the words chosen. And fourth, commercial sense is only relevant to the extent of how matters would or could have been perceived by the parties or a reasonable person in the position of the parties. In essence, in Arnold, the Supreme Court reminded us that primary importance should be attached to the contractual words used by the parties, and that surrounding circumstances and the knowledge of the parties at the time of the contract are only relevant as tools to interpret the language that has been used. Turning then to specifically contractual machinery and service charges. Now, I want to say at the start of this slide that when preparing a service charge demand, it's important to have in mind that there is a possibility that the court may be scrutinising that demand in order to determine its validity at some point in the future. So when drafting them, that should always be in the back of one's mind. On the slide, I highlight some of the considerations to bear in mind when demanding service charge. First of all, if demanding interim payment on account, one should bear in mind the following. The right to demand an interim payment on account should be expressly provided for in the terms of the lease itself. In the absence of an express right to an interim payment, the courts will not readily imply such a right. The lease may specify steps which must be taken by the landlord or managing agent before interim service charges fall due, and failure to comply with those contractual provisions will render them the interim service charge demands invalid. Another point to consider is time of the essence. At common law, unless a lease specifies otherwise, time is not of the essence in preparation of a landlord's service charge account for any particular accounting period. The usual issue is where the lease provides, for example, accounts to be prepared and served within X months of the end of each accounting year. However, case law suggests that such provisions do not make time of the essence. Another point to consider is the matter of certification and demands. It's common for a lease to provide that for service charges to be recoverable by the landlord for any given accounting period, the amount needs to be determined or certified by an accountant. In such circumstances, the issue of a valid certificate complying with the lease provisions will usually be a condition precedent to the obligation to pay service charges. The consequences of failing to comply are that the service charges will not be due, and that particular point was made in the Acarita and Marina Heights St Leonard's Limited decision. A sub-issue within certification and demands is the issue of whether certificates are conclusive or binding, and whether they're expressed to be so under the terms of the lease. Where a certificate is not said to be conclusive or binding on the parties as to the matter set out in the certificate, then of course the matters in the certificate can be challenged. And that particular point follows as a matter of logic, but was also made in the Universities Superannuation Scheme Limited and Marks and Spencer plc decision. It is common, however, for leases to provide that the certificate of the landlord will be final or conclusive. But it's important to bear in mind that in the residential context, this kind of provision will generally not oust the jurisdiction of the tribunal to determine whether the service charge is reasonable or payable. And authority for that is Oliver and Sheffield City Council, 2017 EWC A Civ 225. On the issue of conclusiveness, I would like to draw your attention to the relatively recent decision of the Supreme Court in Sarah and Hossain Asset Holdings Limited and Black's Outdoor Retail Limited. There, the tenant rented commercial retail premises from the landlord. The leases stated that the landlord should provide a certificate each year setting out the service charge sum payable by the tenant. The relevant clause stated that the landlord should provide a certificate as to the amount of the total cost and the sum payable by the tenant, and that this was to be conclusive in the absence of manifest or mathematical error or fraud. In that case, the tenant refused to pay around £400,000 of service charge on the basis that the service charge included things that were not properly due under the terms of the lease, was excessive, and included unnecessary items. The landlord issued proceedings seeking summary judgment for the outstanding service charge, having served a conclusive certificate under the terms of the lease. And they said that following the terms of the lease, that the only defences were manifest error or mathematical error or fraud, not challenges based on sums not being due under the terms of the lease. There was a lot of back and forth in the between the first judgment and subsequent appeal judgments, but ultimately the Supreme Court held that type of provision under consideration in that case was a pay now, argue later provision. The landlord, in short, was entitled to summary judgment on the service charge as a result of the certificate being conclusive, but this did not prevent, in the Supreme Court's view, the tenant later disputing the amount of the service charge in the courts. At paragraph 52, the Supreme Court said, payment of the certified sum does not, however, preclude the tenant from thereafter disputing liability for that payment. The burden will, however, be on the tenant to pursue and establish any such claims. The landlord's cash flow position is therefore protected, whilst the tenant is not deprived of the possibility of pursuing arguable claims. Now, in that, that was a majority Supreme Court decision, and Lord Briggs gave a dissenting judgment, which is well worth a read. But it's important to note that in this context, an awful lot will turn on the specific terms of the lease in question. Turning then to valid demands, section 47 of the Landlord and Tenant Act 1987. This provision provides, where any written demand is given to a tenant of premises to which this part applies, the demand must contain the following information, namely the name and address of the landlord, and if that address is not in England and Wales, an address in England and Wales at which notices, including notices and proceedings, may be served on the landlord by the tenant. Where a tenant of any such premises is given such a demand, but it does not contain any information required to be contained in it by virtue of subsection 1, any part of the amount demanded, which consists of a service charge or an administration charge, shall be treated for all purposes as not being due from the tenant to the landlord at any time before that information is furnished by the landlord by notice given to the tenant. And demand in that provision means demand for rent or other sums payable to the landlord under the terms of the tenancy. So we're including within that administration charge and service charge. Now, where reference is made to this part applies, section 46 says this part applies to premises which consist of or include a dwelling and are not held under a tenancy to which part 2 of the Landlord and Tenant Act 1954 applies. So we're looking at residential tenancies, not business tenancies. Now, points to note on section 47, the purpose of this requirement is to let the tenant know who the landlord is. The requirement is to provide the landlord's address. The requirement to provide the landlord's address is not satisfied by providing the address of the landlord's managing agent, and authority for that is the Bite of Properties Limited decision. Where you have a corporate landlord, the address should be that of their registered office or the place where they carry on business, and again, authority for that is the Bite of Properties Limited decision. If the landlord is an individual, then it must be, the address provided must be the residential address of the landlord or the place where they carry on business. Where the demand contains more than one name and address, it's necessary to identify which one of those names and addresses relate to the landlord. And authority for that is the Telder and Cameret decision, which held that where you have a demand that refers to two companies and two addresses, that notice will be invalid if it does not indicate which one of those two is the landlord. So the upshot is that a leaseholder should not be left to guess who the landlord is. Continuing with the fun under section 47, it has been held by the upper tribunal that it is suspensory only. Namely, once information in compliance with section 47 has been provided to the tenant, the provisions under section 47.2 no longer bite. And authority for that is the Tedler decision. Now, a related point that often comes up when considering these sorts of issues is that, particularly when acting for landlords, it's important to note that generally it's inappropriate for the tribunal to raise a point that the landlord has failed to serve a compliant demand unless the point has been expressly raised by the tenant. And that point is made in the Triple Rose decision. But the way, of course, to avoid any sort of issue like this is simply to provide a valid Section 47 notice, which should really read along the lines of your landlord is X and your address, his or her address is X. Here, I'd also like to mention the decision of Roberts and Countryside Residential Southwest Limited, which is a decision of the Upper Tribunal, where it was held that a solicitor's letter before action, accompanied by the appropriate summaries of rights and obligations and the information required under Section 47 and 48, can be a valid demand. So such a letter is capable of remedying previously defective demands and bringing an end to any suspension of a liability to pay. Moving then to Section 48 of the Landlord and Tenant Act 1987. This provides a landlord of premises to which this part applies shall by notice furnish the tenant with an address in England and Wales at which notices, including notices in proceedings, may be served on him by the tenant. Where a landlord of any such premises fails to comply with subsection 1, any rent, service charge or administration charge otherwise due from the tenant to the landlord shall be treated for all purposes as not being due from the tenant to the landlord at any time before the landlord does comply with that subsection. So it follows from this that failure to properly comply with this provision will result in rent or service charges or administration charges not being considered due. That follows from an actual reading of the provision and also is put beyond doubt by the decision of the court in Dalhold Estates UK Property Limited and Lindsay Trading Properties Incorporated. Importantly, it should be noted that there is no specific form or art to giving Section 48 notices. We're not dealing with something like Section 8 or Section 21, which have specific forms. We simply have to be providing a notice in writing. Time limits. I'm going to discuss here Section 20B of the Landlord and Tenant Act 1985. As made clear in Section 18 of the LPA 1985, this provision applies to tenants of dwellings as opposed to, say, commercial tenants. Section 20B1 provides that service charges must be demanded within 18 months of them being incurred. It's therefore important that a demand for charges is issued within time to avoid any charges becoming time barred from recovery. Section 20B2 provides, however, that if a landlord serves a written notice on the tenant within 18 months of incurring costs, informing the tenant that those costs have been incurred and that they will subsequently be demanded, then such costs can be recoverable. Now, I will come back to this provision in a few slides' time because there are a series of amendments that are likely to be inbound as a result of the Leasehold and Freehold Reform Bill. And indeed, the same is true of Section 21B, which at present provides, in addition and as a result of the 2007 regulations referred to on the slide, that a demand for payment of service charge must be accompanied by a summary of the rights and obligations of tenants of dwellings. Again, Section 21B is suspensory in nature. If the landlord fails to comply with Section 21B, the tenants are not liable to pay service charges until such time as the landlord complies. Further, in respect of that summary of rights and obligations, there is one set for service charges and one set for administration charges. And a practical tip is simply to avoid providing the wrong summary, to always provide both. And In terms of relevant authority on this particular provision, there is Tudor Roberts and Countryside Residential South West Limited, where it was held that errors in the font size, in paragraph numbering, the order in which the information was provided were held to be trivial defects. And so those things did not prevent the summary provided in that case from being valid. So I said I was going to come back to the Leasehold and Freehold Reform Bill. I'd like to conclude with a few comments on this. This bill is currently on its second reading in the House of Lords. The version of the bill which went from the House of Commons to the House of Lords in Part 4 contains a plethora of amendments to the 1985 Act and other acts, so far as service charges are concerned. The .gov guide to the bill states in respect of service charges that the bill will require transparency over leaseholders' service charges. So all leaseholders receive better transparency over the costs they are being charged by their freeholder or managing agent in a standardised comparable format, and can scrutinise and better challenge them if they are unreasonable. Part 4 is, in my view, well worth a read. There are a lot of amendments in there. I certainly don't have time to go through the effect of all of them, but for the particular purposes of this talk, there are 3 which are particularly pertinent. The first is provided for in provision 52 of the draft bill, which amends section 20b, which is the time limit on making demands. And there, the new provision provides for a prescribed form of notice telling the tenant that costs incurred will be demanded in the future, whereas at the moment there's no prescribed form. Under this bill, there will be. The second pertinent amendment is provided for in provision 53 of the draft bill, and that deletes section 21b, which is the summary of rights and obligations, and provision is made instead for a new section 21c, which will provide: a landlord may not demand the payment of a service charge unless the demand is in the specified form, contains the specified information, and is provided to the tenant in a specified manner. And specified is said to mean specified in regulations made by the appropriate authority. It goes on to say, accordingly, where a demand for payment of a service charge does not comply with subsection 1, a provision of the lease relating to non-payment or late payment of service charges does not have effect in relation to the service charge. So this again is a new provision, a new thing that will have to be done in the provision of a specified notice demanding service charge. Quite what that will be, and we don't yet know. And finally, the new section 21c will also amend section 47 of the Landlord and Tenant Act 1987 to prevent the need to provide the information in both notices. So under section 21c, this new demand, I think there's a suggestion that some of the information required to be provided under section 47 will also be provided under section 21c. So there are lots of changes that look like they will be coming to the demand of service charges, but precisely what those changes are will depend on what the House of Lords do with the draft bill. Thank you all very much for listening.
Thank you, Peter. Very unkind of you to mention Ireland and Britain. Famous losses. I lost Chartbrook because we were too literal, and lost Ireland and Britain for not being literal enough, so can't win. Our next speaker is Admas. Admas has one of those crossover practices which is a characteristic of these chambers. So his practice spans public law and property law, and he has experience up and down the tribunal system, including at the highest level where he was judicial assistant to Lord Newburgh when Lord Newburgh was the president of that court for some time. So, Admas, over to you.
Thank you very much, Tim, and good evening, everybody. I'm going to be providing an overview of the statutory requirements relating to consultation requirements in the context of leases of dwellings. The requirements that are imposed, which derive from the Landlord and Tenant Act 1985, are part of the statutory overlay on the otherwise private law relationship between the landlord and the tenant. And what we're going to be looking at are requirements to consult with tenants when certain works are envisaged or carried out, and when a service charge arises under certain categories of leases. The principal provisions in terms of the consultation requirements are sections 19, 20 and 20 ZA of the Landlord and Tenant Act 1985, and the nuts and bolts of the consultation requirements are found in those regulations mentioned there, the Service Charge Consultation Requirements, England Regulations 2003, which apply only in relation to England. What's the position in a sentence? Well, if one is in a situation where the consultation requirements apply and the landlord fails to either comply with those consultation requirements or to seek dispensation from them, then the contribution of tenants is limited to £250 per tenant in the case of qualifying works, or £100 per tenant in the case of qualifying long-term agreements. So we're going to unpack that summary in a bit more detail. But the core of it, or the principal source for the consultation requirement, is found in Section 20 of the 1985 Act. And what that provides is that the relevant contributions of tenants are limited to the qualifying amount, come on to what that means, unless the consultation requirements have either been complied with or dispensed with. Relevant contributions, what does that mean? That's the amount the tenant is required to pay under the lease to contribute to the service charge. The service charge, which look at what Section 18 gives us a definition of the service charge, which is helpful by way of context, statutory context. Service charge means an amount payable by a tenant of a dwelling as part of or in addition to the rent, which is payable directly or indirectly for services, repairs, maintenance, improvements, insurance, or the landlord's costs of management. So if we just come back to Section 20, the cap that it places is on the relevant contributions of tenants. So relevant contributions are the amounts that the tenant is required to pay under the terms of the lease to contribute to relevant costs under the service charge. The service charge is a charge directed at those services there. So when does this, before we look at what the consultation requirement actually requires in terms of the details, when does it apply? It applies to qualifying works or qualifying long-term agreements. So let's unpack what those terms mean. Qualifying works are defined in Section 20 ZA subsection 2. These provisions, I should add, were inserted into the 1985 Act by the Commonhold and Leasehold Reform Act 2002. So that's why we see the regulations coming in force in 2003. So they're defined in that provision as works on a building or any other premises. That's a pretty broad concept that we have there. The elucidation of it in case law to the extent it's required. We've got some in the Paddington case where it was clarified that works really mean building works. So window cleaning, for example, that arose in that case, didn't fall within the definition of works. Section 20, so in relation to qualifying works, that first category that falls within the consultation requirement, Section 20 and the consultation requirements apply where the costs or estimated costs to be incurred in connection with those works exceed an appropriate amount. What's an appropriate amount? An amount which results in the relevant contribution of any tenant being more than £250. So if you're carrying out works and any tenant is required under the terms of the lease to be contributing more than £250 on a building or any other premises, then we have qualifying works, and you either need to comply or seek dispensation from the consultation requirements. Second scenario in which the consultation requirements apply is where you have a qualifying long-term agreement, and that's defined. The positive definition is an agreement entered into by the landlord or superior landlord for a term of more than 12 months. It's subject to a number of exclusions in Regulation 3, including as to leases that were in force prior to the coming in force of the regulations in 2003. So if you have a QLTA, a qualifying long-term agreement, then Section 20 and the requirements apply where relevant costs incurred thereunder in any accounting period result in the relevant contribution of any tenant in that relevant period being more than £100. So where the costs in relation to the matters to which the service charge can be properly directed result in the contribution of any tenant being more than £100, then you have the consultation requirements and you need to either comply with them or seek dispensation. So it's a lower threshold as regards a qualifying long-term agreement. So we'll see already that these requirements will apply in pretty wide, pretty large category of tenancies as regards dwellings. What is the purpose of the consultation requirements and why are they there at all? Now, when I started, I mentioned that this was part of the statutory overlay that we have in the private law relationship, and the courts have interpreted the consultation requirements as one would expect, really within that context and as of a piece with some of the other provisions in the 1985 Act. And in particular, what might be described as the centrepiece of the protection of tenants in relation to service charges, which is the requirement of reasonableness of service charges, which Peter touched on briefly in his talk. And we find that in section 19. And just to remind ourselves what section 19 does in terms of limiting the service charge under a lease of a dwelling, it provides that costs or estimated costs incurred or to be incurred in connection with matters for which a service charge is payable shall be taken into account in determining the amount of a service charge only to the extent that the costs are reasonably incurred and where they're incurred on the provision of services or the carrying out of works only if the services or works are of a reasonable standard. So if you're a landlord, you can't seek to recoup from tenants costs via service charge unless they're reasonably incurred and they're of a reasonable standard. So that's the more might be described as the centerpiece of that part of the 1985 Act. And what the court has said, what the Supreme Court has said in Dejan Investments is the purpose of the consultation requirements is really to make sure that the service charges that they are contractually obliged to pay do comport with that reasonableness requirement. It allows, those requirements ensure that tenants are protected from paying for inappropriate works, and they ensure that tenants are protected from paying more than would be appropriate. That's what they're about. And that was in the context where the Supreme Court considered and ultimately rejected broader arguments about the purpose of the consultation requirements, which were to the effect that they were directed at transparency and accountability more generally. And the court said, no, that's not what they're about. Yes, this is about consultation, but it's not about generally inviting the tenant into the decision-making process and them feeling secure in the transparency of the decision-making process and those kinds of matters. So that's an important point of context, overall context, when we think about how these are supposed to be working in practice. So then let's turn to look in a little more detail at the nuts and bolts of what is required. So the details of what one needs to do are found in the schedules to the regulations, and there are a number of different categories of requirements that arise. You have requirements depending on whether the obligation arises because on the basis of qualifying works, or whether it arises on the basis of a qualifying long-term agreement, or under both. And we'll go through those in a moment. And it's just worth noting that there are different consultation requirements that arise where public procurement requirements apply to the works or to the agreement. The thresholds and definitions for when those requirements apply are set out in the Public Contracts Regulations 2015, and they will require public notice of what is proposed. So we're not going to go into that. This isn't a procurement tool, but it's just to note that there are separate consultation requirements in that situation, and the regulations cater for those separate categories as set out in that list there. So just go through in a little bit more detail what is required in the more normal case. So where the consultation requirements arise under a qualifying long-term agreement, the landlord has to give notice, and this is Schedule 1 of the regulations where this is all set out. The landlord has to give notice in writing of an intention to enter into the relevant agreement to provide the services to which the service charge is required. And that notice has to provide certain information. It has to describe the goods or services to be carried out, specify the place, hours at which the description may be inspected. The notice has to explain why the landlord considers the goods/services necessary, or where one is dealing with works, to explain why it's necessary to carry out those works. The landlord has to invite observations from the tenants. Once those observations are forthcoming, the landlord then has the duty to have regard to the observations made, and we'll look at what that means in a moment. The notice should also invite tenants, or where applicable a tenants association, to propose the name of any person from whom the landlord should try to obtain an estimate. So that's a explicit basis for the tenants to propose somebody that could potentially carry out the works or deliver the services. Once all that has been done, the landlord is under duties to obtain certain estimates. So that's the next stage in the process. They're under a duty to obtain at least one estimate from a person unconnected with them, and to obtain at least one estimate, subject to certain exceptions, where there have been where someone's been nominated or proposed by a tenant or tenant association. So the landlord obtains those estimates, and then based on all that, the next stage, the landlord prepares a proposal of what is to be done and gives notice to the tenant. At least one proposal is to provide goods and services to be provided by a person wholly unconnected with the landlord. Where an estimate has been obtained with a nominated person, that's a person that has been suggested by a tenant or tenants association, there has to be a proposal based on that estimate. The landlord has to set out the intended duration of the proposed agreement. And the landlord also has to set out a statement or provide a statement setting out what observations have been received in response and the landlord's response to them. And then the landlord has a duty to have regard again to observations made in regard to the proposals. So as well as in relation to the notice comes in, you get your estimates, you go back with proposals, and then the tenants have an opportunity to make observations on the proposals, and the landlord has a duty yet again to have regard to observations made in regard to the proposals. If the landlord decides to enter into an agreement, then there's another duty to give notice to each tenant and any recognised tenants association, stating a number of factors, including the reason for making the agreement and setting out observations on setting out the landlord's response to observations made in regard to the proposals. So it's I also practice in public law as well as in property law, and there's a distinct public law duty type flavour to this process. We can see where the landlord is having to take account of what the tenants are saying, have regard to them, and explain their response. But that's what the regulations require. So that was under where the obligation arises under a qualifying long-term agreement. Schedule 3 deals with where the obligation arises under a qualifying for qualifying works under a qualifying long-term agreement, and the consultation requirements are very similar to those in Schedule 1, but somewhat reduced. There has to be a notice in writing, so the initial stage. There's a duty to have regard to observations on that notice, and then there's a duty to respond to observations within 21 days. So it's a reduced series of duties. Schedule 4, Part 2 deals with the consultation requirements in relation to qualifying works, and there again it's similar. The landlord is to give notice in writing to tenants, to have regard to observations in relation to proposed works, the duty to obtain certain estimates, much as in Schedule 1, and to invite observations thereon and have regard to those observations. So that's in relation to estimates. And then, as with Schedule 1, where the landlord does enter into an agreement, duty to give notice to the tenant. So the consultation requirements are very similar in the three situations, with slight tweaks in between the three, but for the detail of them, the place to go is the schedules to the regulations. So one of the common factors is the duty to have regard to observations, which is a slightly alien concept, certainly in private law, increasingly less so, but is a very well developed one in the public law context. And some guidance on what that entails in practice is given by the Court of Appeal in the Waller and Hounslow case. And drawing significantly on the public law principles governing the duty to have regard to consultation responses, what the Court of Appeal says that the landlord must conscientiously consider the lessee's observations and give them due weight, depending on the nature and cogency of the observations. It's also said that given that the statutory framework requires the tenant's views to be obtained, it's impossible to say that their views are ever immaterial. They will have to be considered in every case. This does not mean that the lessees have any kind of veto of what the landlord does, or that they're entitled to insist upon the cheapest possible way of achieving the landlord's objective. But the landlord can't simply tell the tenants what they're going to do. It's a bit more than that. What the landlord does not have is an obligation to inquire into the tenants' views further. That is beyond what the regulations provide. And taking a step back, what's the point of all this? Well, the statutory consultation process is designed to inform the landlord about the tenants' views. So, as a lawyer, that makes sense to me. One wonders in practice how easy that will be to apply. But the long and short of it is, you have to take account of what is said, but you're not obliged to follow a recommendation that's made by a tenant through an observation. So you recall that we started by looking at what Section 20 requires, and it imposes a requirement to either comply with those consultation requirements or to have obtained dispensation from them. And the for the framework for seeking dispensation, we look to 20 ZA of the 1985 Act, and that provides that a landlord may seek dispensation from all or any consultation requirements on an application to the appropriate tribunal. That's the first tier tribunal in England, and a leasehold valuation tribunal in Wales. The principles that are applied in the context of an application for dispensation were set out in the Dejak case, in the Supreme Court case, summarised by the Upper Tribunal in the Jastrzębski and Westminster Council case. And 5 factors that the tribunal will consider in deciding whether or not to grant dispensation from consultation requirements. First of all, the question will be asked whether, and if so, to what extent, the tenant would relevantly suffer if an unconditional dispensation were to be granted. Relevantly suffer, what does that mean? It refers to a disadvantage that the tenant would not have suffered if the consultation requirements had been fully complied with, but will suffer if unconditional dispensation were granted. So one looks at the position of the tenant if there had been full compliance, one looks at the position of the tenant where there's unconditional dispensation, and that's the suffering between those 2 points is what one looks to, and the extent of it, if it's there. The burden is on the tenant to identify that relevant prejudice, which they claim they would or might have suffered. So the starting point is for the tenant to show the tribunal that there is some relevant prejudice they would suffer on dispensation, on providing dispensation from the requirements. What the tenant has to show is a credible case for prejudice. Once a credible case for prejudice has been shown, then the tribunal looks to the landlord to rebut that case, to say, well, no, there isn't any real prejudice. In the end, the tenant's position is pretty much in substance the same. If the landlord can't rebut that credible case for prejudice, then the guidance is that the tribunal should, in the absence of a good reason to the contrary, require the landlord to reduce the amount claimed as service charges to compensate the tenants fully for whatever prejudice is found. So the tribunal, unless the landlord can rebut the credible case for prejudice, will look to reduce the amount claimed as service charge to compensate the tenants fully for the prejudice that they have alleged. Fourth, it's the position is that the tribunal will not seek to distinguish, or it's not sensible, it's considered that it's not sensible for it to seek to distinguish between what is described as a serious failing and a technical, minor or excusable oversight, except on the basis of that prejudice. So it's really to say the focus is on that question of prejudice. The question of the gravity of the landlord's failure to comply, the question of culpability of the landlord, the nature of the landlord, financial consequences of its failure to comply are not per se relevant considerations for the tribunal. And this goes back to the point made by Lord Newberger in Dejan Investments, that this isn't a license for transparency to the tenants. It's not a general decision-making process, approval process. It's really about focusing on whether what's the service charges are reasonable. It's an enforcement mechanism in a way for the reasonableness of the service charges. And last, the tribunal could, as in has jurisdiction to, grant dispensation on such terms as it thought fit, I should say, missing word there, providing the terms were appropriate in their nature and effect, including terms as to cost. It's not limited by, it doesn't have to just give unconditional dispensation or nothing at all. It can fall somewhere in the middle. So those are the options really for a landlord who finds that they fall within section 20. You've either got to comply with those consultation requirements or you've got to seek dispensation. So that's the overview. So some key points, standing back. What do we need to ask ourselves? Are consultation requirements engaged? Is this a qualifying works or qualifying long-term agreement situation? We've seen those are very broad concepts. And for the content of the requirements, we refer to the schedules to the regulations. So schedules 1, 3, and 4 part 2 are those that govern situations where you don't have procurement obligations applying. So this is a normal situation. And it's important to bear in mind the tribunal's quite broad jurisdiction to grant dispensation, which will be in the light of looking at what the purpose of these consultation requirements are, and that they are ultimately focused on making sure that the service charge is a reasonable one. The requirements are about making sure tenants are protected from paying for inappropriate works or paying more than would be appropriate. Compliance is important, but it's not a broader license for the requirements are not a broader license for transparency or a veto of the landlord's discharge of duties. And that purpose is to be borne in mind in considering how these requirements apply in any particular situation. So thank you very much. That brings an end to my talk, and I'll hand over to Tim and then Kim.
Thank you for providing some insight into that rather technical subject. Our next speaker is Kim, and Kim is a specialist property and planning practitioner with particular expertise in the overlap between those two spheres of practice. And on the property side, her practice spans the full range of property work. She's often in the sorts of tribunal where service charges crop up for disputes, FTT, residential property chamber, in relation to service charges and right to manage and enfranchisement issues. And her clients cover a broad spectrum: large corporate landlords, residents associations, and individual tenants. So she's as well placed as anyone to tell us about the murky waters of FTT procedure, which is what she's going to be speaking about.
Thank you, Tim, and thank you, everyone. Good evening, just about, I think, into evening territory. I have to admit that when I was asked to speak about procedure in the FTT, my initial response was, is there such a thing? And I think it can be a bit infamous for being a little bit of a Wild West sometimes when it comes to procedural rules. It's certainly not exactly the same as being in a county court or high court where you've got the nice big white book that governs everything and anything that you could possibly think of from a procedural perspective. However, having said that, it's probably a slightly unfair response from me. There are clear procedural rules that are set out, and we'll go through those. And the FTT does have a lot of powers when it comes to case management and how to take things forwards and managing the procedure of matters that come before it. And I actually think that the more familiar practitioners are with those rules, the better these cases can be managed going forwards, and that parties have an important role to play in making sure that those procedures are followed appropriately. So let's start with the very basics of what is the first tier tribunal. Well, of course, it's a creature of statute, and as a result of that, its jurisdiction and powers are strictly governed by the relevant statutory rules which confer those powers upon it. It's part of a streamlined two-tier tribunal system with appeals going up to the upper tribunal. We're focused here on the property chamber specifically, which has jurisdiction over a wide range of property-related disputes. But that is then in itself divided between residential property chamber, agricultural lands and drainage, and then land registration matters. So residential property chamber is really going to be the focus of my talk today, because that is the part of FTT that deals with service charges as well as other landlord and tenant disputes and residential property matters. The applicable rules are those set out in the Property Chamber Tribunal Procedure FTT rules 2013, and as they've been amended variously over the years. And those are available online. Just Google them and you will find them. They're quite detailed, and I think people are often not as familiar with them as maybe they might be. It's worth noting as well that there are separate practice directions that supplement those rules, and particularly in relation to residential property disputes, which we're concerned with today, and service charges. They set out some additional requirements. Those are also available online. When you go on the FTT's website, you'll be navigated through to that practice direction. So, starting an application in the FTT, let's start at the beginning and stepping back. But when the first tribunal is like any court or like as any jurisdiction, they are trying to consider the arguments and the evidence before them that is brought before them by the parties. When there's a hearing, of course, the tribunal members can ask questions and they can seek to interrogate that evidence, but they can't go and find the evidence for themselves. They have to make a decision based on what is brought before them. And so it's very important that the parties work constructively with the tribunal and each other to ensure that the proper information is before the tribunal. And that is a particular problem that I come across a lot in practice in these kinds of cases, because there are often litigants in person on one side, usually in terms of the leaseholders, and there can be vast swathes of documents that are relevant in service charge disputes, but also a whole load of other information that is not really relevant, that just sort of gets dumped potentially on tenants, or that landlords are trying to gather from various managing agents that have often changed hands about 10 times in the last 5 years, and difficulties gathering historic evidence that it might be relevant to service charges. And it can all get very messy. And I think trying to sort of stand back from that and make sure that what the tribunal has before it when it's making its decision is the most relevant and important information that it needs can be a really, really essential part of running these cases properly and getting good decisions from the tribunal. So, how do you start proceedings in the tribunal? Well, they must be started according to Rule 26 by sending or delivering a notice of application to the tribunal, and there are model forms in relation to Section 27A applications. So those are applications governing the reasonableness of service charges. And also 20ZA applications that Admas talked about in terms of dispensation from consultation requirements. Those are available online. You can also get them in hard copy, I am told, from the tribunal building, but I'm not sure I'm convinced by that. Online is probably your safest option. There are, as I say, there are other requirements specified in Rule 26.2 of the procedural rules themselves as to what needs to be set out in those documents, but if you follow the model forms, you should be okay. And the relevant practice directions supplementing the rules will tell you other documentation that you need to provide with your application. So do go and check that before you start. There are time limits dealt with in Rule 27, but that doesn't really apply in relation to service charges. In terms of those specific rules, obviously there will be time limits in terms of recovery of service charges based on it being a contractual claim. In terms of Rule 29, this is where, so once the tribunal receives the notice of an application in your model form, it must then provide a copy of it and any accompanying documents to the respondent, whoever's named as the respondent, and also to various other people in terms of applications dealing with service charges. Those include the secretary of any recognised tenants association and any other person, such as other leaseholders whose name and address is known to the tribunal and it considers it will be likely affected by the application. So the tribunal will get the application and it will then send it out to the relevant people who need to see it. The notice that's sent to the respondent will inform the respondent of the rules under Rule 30 for responding to that application. And those rules include that the respondent will generally have 28 days from the date on which the tribunal provides them with notice of the application to respond to the application. Again, this is all unless the tribunal directs otherwise. Sometimes the tribunal might, for example, I had a case a few weeks ago where the tribunal saw the application, realised there was a potential jurisdictional issue as to whether actually what was being challenged here was something that the tribunal should be dealing with, and instead of directing the respondent to put in a response, just directed there be a case management conference to discuss that potential jurisdictional issue. It's also possible to agree an extension of time if that 28-day period isn't going to be sufficient to respond, but that agreement must then be approved by the tribunal. Don't assume that just because you've agreed it with the other side, the tribunal will be okay with it. You need to send off effectively a consent order to the tribunal and get them to approve it in order to be sure that you're not going to be in breach of the rules. The response must address the matters that are set out in Rule 30, subparagraph 4, which tells you what, and also that will tell you what documents you need to be appending to your response. So once you've got your applications in and the responses come in from the respondent and anyone else who's affected by the application, you then get on to case management. So this is where in a normal county court proceeding, you'd be looking at a case management conference or something like that. Now, that can happen in tribunal cases. Usually in more complex service charge disputes, the tribunal will more and more often now direct that there be a case management conference, usually a virtual one, listed for an hour or so, or where there's a question over jurisdiction, so that the parties can try to agree directions and go through how the case should be managed going forwards. Now, it's always worth ahead of those hearings, in the same way as you would in the county court, trying to agree directions with the other side. There are no set or standard directions set by the tribunal, but it's worth thinking about what is going to be important here. What kind of documentation are you going to need from the other side? Do you think there's going to be expert evidence required in this kinds of case? How many witnesses do we think you're going to be calling? Is it important that it takes place in person, or are you open to it taking place virtually? Does there need to be a site visit, for example? There's all sorts of, those are the kinds of questions you need to be thinking about based on the material that you've got in the application and in the response. Also, whether you need more particulars from either side to actually understand what their case is. And things in, one thing in a service charge dispute that can be particularly useful is a Scots schedule, and that will almost always be directed by the tribunal, which is effectively just a table where the tenants, say the application is made by the tenants challenging the reasonableness of service charges, they'll set out precisely which service charges they're challenging and why, and the landlord will then respond as to why they say that those charges are reasonably incurred. And that's a very, very useful document for sort of honing in the issues. Now, the tribunal has, as set out on the slide, general power under Rule 6 to regulate its own procedure, and that includes various actions such as extending or shortening time for compliance with a rule, dealing with an issue as a preliminary issue, adjourning or postponing a hearing, and staying proceedings, much like you would expect in a court. There's a whole load of other things that are listed there as well. In that rule, so it's got a general power to regulate its own procedure, and it's worth noting that any party can apply to the tribunal for a direction under Rule 6, subparagraph 2, under Rule 6, but that application must simply set out the reason for making the application, and unless it's made by consent, a copy of that application should be sent to every other party before it's made to the tribunal. So if you need, for example, further disclosure from the other side, or if there are particular documents that you want to see and they're not agreeing to do it by consent, you can make an application to the tribunal for that. And my top tips really here at this stage is just to get your ducks in a row if you haven't already done so. If you're applying on behalf of a landlord, if you're applying on behalf of a leaseholder, what evidence of unreasonableness do you actually have when you're trying to challenge some service charges that have been demanded by the landlord? So often I see leaseholders who say, well, they've just gone up, they've gone up unreasonably, and that must be unreasonable because it's much more expensive than it was before. Unfortunately, that's very rarely going to fly with the tribunal. It's not enough. Have you gone to get alternative quotes for the same works? Can you show that these works really aren't necessary because you're paying for a gardener and there's no garden? And similarly for the landlord, trying to get your ducks in a row, either as the applicant or the respondent, of where am I going to get all the documents that show all the things that Peter talked about in terms of that I've complied with the lease in demanding these service charges, that they were demanded properly, that they were sent to the right, that the tenants had the address that they needed to have in order for me to be able to even demand these service charges. Because all of those things are going to come up later, and they can often get left till the last minute, and this is how you end up with lots of last paperwork coming before the tribunal and no one really knowing what's going on. So the sooner you can work out where those documents are, and if you're going to have to go and seek them, for example, from an old managing agent that has changed over, are you going to need to use the tribunal's powers to force them to produce documents, or are they going to actually be helpful? How long are you going to need to do that? All of that can be factored in, but you need to know in advance that those are things you're going to need. Expert evidence is another thing that often people don't think about until slightly further on in the tribunal process, but you need, and as I'll come on to, in fact it's on the next slide, you need permission from the tribunal in order to rely on expert evidence. And I think, again, often leaseholders can think, oh, well, it's obviously not right, but this is being done in this way, and there's another way of doing this kind of work, without really thinking about the fact that that's a question for an expert, really, isn't it? In a lot of cases, if you're saying that roof works need to be done in a particular way and not another, the sooner you can go and get that and understand what you're going to require, the sooner you can make sure that that's all provided for in the relevant directions. So yes, Rule 19 governs the expert evidence. As in the court, there's none without permission from the tribunal, none is permitted without express permission from the tribunal. And often the tribunal will think about directing a single joint expert if that makes sense in a particular case. And there's a huge amount of control provided in that rule over what the tribunal over what expert evidence can be brought in what form, and how that's to be done. Rule 21 also provides specifically for site inspections, allowing the tribunal to inspect the land, property or premises if that might assist it in reaching its decision, which often it will, depending on the nature of the things at issue. But when you're talking about services and service charges, it's often helpful for the tribunal to have a sense of what the property looks like and what the common parts are that these service charges are payable in respect of. So what happens if you don't comply with all of these rules? Well, again, there's a general discretion really here for the tribunal to take such action as it considers to be just, and that's set out in Rule 8 of the tribunal rules. And it's worth noting that, similarly to in the civil procedure rules, a failure to comply with the procedural rules does not in and of itself render void proceedings or any step taken in the proceedings. So you need to get a direction or an order from the tribunal saying what the sanction is to be effectively. There are no automatic sanctions unless that's been provided for in a direction by the tribunal previously. So what steps can the tribunal take? Well, they could just choose to waive the requirement if it's been a fairly minor breach. They could require the failure to be remedied. They could strike out your case. That's obviously one of the most significant ones. Or bar or restrict a party's participation in the proceedings. And that's normally done in respect of respondents, where it's not so much a case of striking out their application, but barring them from continuing to be involved in the proceedings. So there's obviously some quite serious powers there for the FTT, and it's got a wide discretion So, my tip is always that it's better to get permission or approval in advance than to try and seek forgiveness after, even in a jurisdiction that can sometimes feel more informal than others. There are rules and they will be followed, and the other side could ask the tribunal to exercise some of these more serious sanctions. So it is worth making sure you're keeping in compliance with the rules. In terms of strikeout, that's governed more in more detail under Rule 9. And there are basically two, similarly again to in the county court, but there are two different types of application or powers here. There are cases where the tribunal must strike out the whole or part of a case, for example, in circumstances where it does not have jurisdiction in relation to the whole or part of the proceedings, and it has not transferred the whole or the part of the proceedings to another court or tribunal. So this is again coming down to the tribunal being a creature of statute and its jurisdiction being limited by that which is conferred upon it by the particular statutes that we're concerned with. In terms of transfer, there are specific rules, for example, in the Common Hold and Leasehold Reform Act for referring certain points to either from the county court to the FTT or vice versa, where there are things that come up in service charge cases that are not governed by the FTT's jurisdiction or are exclusively governed by the FTT's jurisdiction. And there's this slightly new phenomenon, or relatively new phenomenon of double hatting, which some of you may have heard of, whereby an FTT judge, who is also qualified to sit as a county court, as a deputy judge in the county court, as a district judge in the county court, can sit as both effectively in the same set of proceedings to govern matters that are covered by both jurisdictions. I've done one case management conference in such a case, and I can tell you it gets quite messy when you're trying to apply tribunal procedure rules and civil procedure rules at the same time. And I think it might have settled or it's gone somewhere else, but I don't know how many of those have actually proceeded all the way through to a final hearing. But it can get a little bit messy. But in any event, if we are just dealing with an FTT application and the FTT does not have jurisdiction in relation to that part of the proceedings, it must either transfer it over to the relevant court or strike out the application. In other circumstances, the FTT may strike out the whole or part of a case where, for example, there's been a failure to comply with directions stating, and specifically if there's a direction that states that non-compliance by a specified date will lead to the application being struck out, so similar to an unless order in the court, or where the applicant has failed to cooperate with the tribunal so that the matter cannot be dealt with in a fair and just way. Other situations in which the tribunal may strike out the whole or the part of the case are where the proceedings are between the same parties and arise out of facts similar or substantially the same as those contained in proceedings already decided by the tribunal, so it's sort of abusive process type cases, or also where the tribunal considers that the proceedings or the manner in which they are being conducted are frivolous or vexatious, or where the tribunal considers that there is no reasonable prospect of the applicant's case succeeding. So again, very similar to strikeout powers of a county court. A decision to strike out cannot be made unless the parties have been given an opportunity to make representations, unless there's been, except in that first circumstance that's shown on the slide there, whereby there's an unless order effectively saying that failure to comply with the direction by a certain date will automatically result in strikeout. And applicants can make applications to the tribunal to have a matter reinstated once it's been struck out, but that needs to be lodged within 28 days of the decision. And just to note that that applies to respondents as it does to applicants, but a reference to striking out in the case of a respondent is barring them from taking further part in the proceedings. So, assuming you've not been struck out and you've complied with the directions and we've ended up in a hearing itself, although just to note that not all cases in the tribunal will end up in will require a hearing, and the parties can consent to an application being determined by a written procedure instead in some more straightforward cases. And often in cases of dispensation from consultation requirements, they'll be dealt with by a written procedure rather than a full hearing. Assuming that there is a hearing, however, then that must be held in public under Rule 33, and 14 days notice minimum will be given. The reality is you often get much more than that because of the listing times in the tribunal, unless of course there are urgent or other exceptional circumstances. And this comes back to what I was saying earlier. Yes, the tribunal is a relatively informal jurisdiction. It's intended to be less formal than a court, but it will follow procedures, and the tribunal will set out what those procedures will be. And how the hearing proceeds is ultimately at the tribunal's discretion. As a rule of thumb, you can assume that it may proceed in a similar way to a county court trial, that you'll have sort of brief opening submissions, but it's particularly by the applicant and by the respondent if that's necessary. Calling of the applicant's witnesses to start with cross-examination and questions by the tribunal members, followed by calling of the respondent's witnesses with cross-examination and questions by the tribunal, and then closing submissions. And you would usually expect the applicant to have the last word. But prepared to be flexible. I've had it happen in all sorts of different ways, including that the tribunal decided to do cross-examination by topic rather than by witness, which was slightly surprising to me, and not something that I had ever prepared for before, so each witness got called and cross-examined on a particular topic, and then we would call them back, but that's how the tribunal wanted to deal with it. And I can see that in some cases we were dealing with quite distinct issues in service charges that can make sense. It's just a case of being prepared, but also being ready to deviate from that plan and see what and do as the tribunal wishes to proceed. What does that mean in terms of practical considerations? Well, ahead of a hearing, of course, the most obvious ones are who needs to attend. Of course, your witnesses will need to be there. And there are particular rules about witnesses attending from abroad, etc., and you'll need to get permission if you want people to attend remotely. So the assumption is if you've got a witness and the hearing is being held in person, the witness should be attending that hearing in person unless you've got good reasons otherwise, and that's been agreed in advance. So do make sure your witnesses are available. You'd want at least a decision maker on the part of the client, either in the room or available. On pretty short notice if you need to take instructions. In terms of documentation, again, there'll usually be directions that set out how this is supposed to be prepared, but as a general rule of thumb, you obviously want all the relevant documentation contained within an organised bundle or set of bundles, and to ensure that there are sufficient copies for the tribunal members, parties, and a clean copy for the witnesses, which often gets forgotten about. Skeleton arguments, chronologies, case summaries might be relevant. It depends on the case. What's almost always going to be useful in a service charge dispute is the Scotch schedule that I discussed earlier, because that can be a really good starting point for the tribunal's determination. One thing to note for virtual hearings, which are happening less now for substantive but do still happen, is just how you're going to communicate with your team. I tend to find setting up a WhatsApp group or something, some way of communicating to be very useful. I've mentioned there that there's provisions in the rules for consent orders and where a party wants to give notice with withdrawing its proceedings, just to say that the tribunal can issue a consent order, but it will need to consider it to be appropriate. So you need to submit your order to the tribunal and then they can approve it. And in terms of withdrawing, a party may give notice of withdrawal, but it doesn't take effect until the tribunal consents to it. So just worth noting those rules. In terms of decisions by the FTT, it may give its decision either orally at the hearing or in writing thereafter, and usually that's more usual in my experience, that the written decision will come afterwards with its reasons, and that will include notification of any right of appeal and the time within which that right needs to be exercised. Looking at appeals then, or corrections, so once you get your decision from the FTT, there's a slip rule, similarly to in the county court, whereby the tribunal may correct a clerical mistake, accidental slip, or omission. There's provision to set aside a decision by the FTT under Rule 51. They have a power to set it aside and remake it if it's in the interests of justice to do so, or various other conditions in the rule are satisfied. However, assuming you've got a decision and it's final, you're not correcting it or setting it aside, but you want to appeal it, then you need to seek permission by making a written application to the tribunal for permission to appeal, and that needs to be made within 28 days of the date on which the tribunal sends written reasons for the decision. The application must include your grounds of appeal. When the FTT receives that application for permission, it must first consider whether to review the decision itself. So it effectively has a right to reconsider its decision in accordance with Rule 55. It should only do so if it's satisfied that one of the grounds of appeal is likely to be successful. And it's worth noting that there is no automatic stay of any decision of the FTT pending an appeal. Any party who wants such a stay must apply for one under Rule 54. So once the tribunal has received the application for permission to appeal, it decides whether to review its own decision or not. If it decides not to, then it must decide whether or not to grant permission to appeal, and if you get that, then off you go to the upper tribunal. Very briefly then on costs, the starting point is that the first tier tribunal is a no costs jurisdiction, and that therefore each party bears their own costs. However, there is a limited power under Rule 13 for the tribunal to make an order for costs in certain circumstances. Those include where there have been wasted costs. Those are costs incurred by a party as a result of improper, unreasonable, or negligent acts or omissions on the part of any legal or other representative, or which in the light of any act or omission occurring after they're heard, the FTT considers unreasonable to expect that party to pay. So this is specifically legal representative costs, legal representative conduct. And more commonly, you see applications for costs where it's said that a person has acted unreasonably. Worth noting that in land registration cases, the costs position is different. So we're looking at service charges here, but if you are dealing with land registration cases, do look carefully at that. And in telecoms cases that are referred to the FTT as well. Now, an order under Rule 13 can be made on the FTT's own initiative or following an application by a party. If you want to make an application for your costs, then you have to make it either orally at the hearing or in writing thereafter, and at the latest within 28 days of a decision notice which finally disposes of all of the issues in the proceedings. The paying party, or the party against whom costs are sought, must be given an opportunity to make representations before an order is made against them. And the order can be for the whole or part of any costs incurred by the seeking party, and that will be determined either by summary assessment, most commonly, agreement if the parties can agree the amount of costs, or detailed assessment, and parties can apply to the county court for such an assessment if necessary. What does it mean? What does unreasonable behaviour mean? This is the most common ground for an application under Rule 13. Well, that was guided, the leading case on that remains the Willow Court management case from 2016, in which the upper tribunal provided guidance on what constitutes unreasonable behaviour. They set out a three-stage analysis which the tribunal should apply when considering an application under Rule 13. The first stage being, has the person acted unreasonably? And that is the application of an objective standard of conduct. This is not a discretion of a tribunal in this first stage. You're applying an objective standard of conduct to the facts of the case. And the acid test is whether there's a reasonable explanation for the conduct complained of. Once you get through that, assuming that unreasonable behaviour has been found at stage one, stage two is to consider whether, in light of that unreasonable behaviour, an order for costs should be made. And this is where the discretion of a tribunal comes in. And assuming an order should be made, discretion continues as to what the terms of that order should be. In terms of exercising the discretion under stages 2 and 3, the tribunal has to have regard to all relevant circumstances. And in Willow Court, the upper tribunal had discussed what those certain cases that may or may not be relevant circumstances to take into account. One thing that the tribunal considered was access to legal advice. As I say, you often do have unrepresented parties in these cases. And that may be a relevant factor for the tribunal to take into account in determining whether a person has or has not acted unreasonably. What it would be reasonable for a legally advised person to do may be different to someone who is a litigant in person. However, they stress that this is not a carte blanche for litigants in person to misuse the tribunal process. They said that a delay in withdrawing proceedings is unlikely to be sufficient because they didn't want to discourage concessions to be made in appropriate cases and disputes to be resolved in that way. Another factor that they considered was causation. So does the unreasonable behaviour have to be directly linked to additional costs or some particular kinds of costs that the receiving party has incurred? And the tribunal said that direct causation is not necessary, although the effect of any unreasonable behaviour, for example, by increasing costs, will be relevant to determining whether or not it's unreasonable in the first place and whether it's appropriate for an order to be made. The takeaways really is that unreasonable behaviour is a very high threshold, especially post-Willow Court, and the burden is on the paying party to demonstrate that the other party's conduct has been unreasonable. And to do that, you need to identify clearly and specifically the conduct relied upon as being unreasonable. It's not good enough to say, oh, well, they've just been a bit annoying, they've been slow in responding to my emails, or they've done this and they've done that. You need clear and concrete examples. And the court stressed, in the Upper Tribunal and Willow Court stressed that applications under Rule 13 should not be regarded as routine. They should not be abused to discourage access to the tribunal and should not be allowed to become major disputes in their own right. And that's been restated by the Upper Tribunal in several more recent cases. And it's worth saying that an order for costs under this rule will only be made in the clearest cases and where the paying party's behaviour has been vexatious, designed to harass the other party, rather than to advance the resolution of the case. So do not assume that Rule 13 is an easy open and shut application to make. Parties should be very carefully advised that when going into tribunal proceedings, the starting point is that they will bear their own costs, except in exceptional circumstances, really. And one thing that I apologise for not covering on the slides, but is relevant given that we're talking about service charges, is that costs and service charges cases can be slightly different, or there's another layer to be thought about, which are the contractual provisions that may exist in a lease for the recovery of legal costs, either as a service charge or as an administration charge. This goes back to looking at the contractual mechanisms that Peter discussed and interpreting any relevant clauses in the lease to see if legal costs are properly recoverable under those clauses. In terms of protection for leaseholders against, in circumstances where there are such contractual recovery provisions in the lease, they can make an application under Section 20C of the 1985 Act, where legal costs might be recoverable as a service charge, which would be an application, but the tribunal fines effectively or makes a determination that legal costs can't be recovered as a service charge, or a similar application under paragraph 5A of Schedule 11 to the Common Hold and Leasehold Reform Act 2002 in relation to administration charges. So to say that legal costs of the proceedings can't be recovered as an administration charge. However, there's no guarantee that the FTT will grant a Section 20C or Para 5A application, and it's usually not determined until after the substantive decision is made, so there's no sort of advanced protection for leaseholders or the certainty that they're not going to have to pay legal costs. And it will often depend on the outcome of the application, because the tribunal will just decide it has a wide discretion of whether or not to grant such applications. I should note, Peter touched on the Leasehold and Reform Bill that is going through Parliament at the moment. Section 20C and paragraph 5A applications, which I just talked about, are currently proposed to be abolished by that bill. That's clauses 60 and 61 of the most recent version of the bill for anyone who's following it. Instead, you will only be able to rely on a cost provision in a lease if a court or tribunal determines that it would be just or equitable for you to do so, and you'll need to make an application in order to rely on that provision. And there'll also be a reciprocal implied indemnity, whether or not it exists in the lease, by the landlord in favour of the leaseholder, so that the leaseholder can apply to say that their costs should be recoverable. Again, you need to make an application, and a court or tribunal needs to determine that it will be just and equitable for you to recover your costs. That, in my view, has potentially very difficult problems in cases involving, for example, unfunded leaseholder management companies or leaseholder owned blocks where there is no funding for legal disputes except through recovery through the service charge. But that is how the bill stands at the moment, and that is what is proposed. Thank you very much, and I think we'll now take any questions.
Well, thank you, Kim, for concluding the evening punctually. We're now at the witching hour of 6:30, having run on slightly. I've got a list of the questions that have come in from the online customers, and the first of them is for Peter, from Peter Cornell, who asks, having heard about this Hossain case, can the pay now, fight about it later argument be applied in a residential context? What's the answer to that?
I can't see why not. It depends what the lease says. Obviously, Sarah and Hossain was a commercial case. But I can't see in principle why the argument can't apply, depending on what the lease says. Of course, bearing in mind that Section 27A in the residential context is the provision that governs, and that says, among other things, that merely the tenant paying an amount doesn't prevent them challenging the reasonableness or otherwise under Section 27A1. So in some ways it seems to reflect the pay now, argue later, or contemplate that as a thing that the tenant would pay and subsequently bring a Section 27A application. In my experience, often a landlord would be, in this sort of context, they would be seeking recovery of unpaid service charge in the county court. And in the context of those proceedings, it could well be that the tenant says, well, I want to make an application to the FTT under Section 27A, and the county court has powers to transfer, which is something that Kim mentioned. And as to whether the court does that before ordering the tenant to pay the service charge or afterwards, I suppose will depend on the wording of the lease. But in principle, I can't see why that argument in and of itself doesn't apply in the residential context. But I think you have to bear in mind Section 27A and the likelihood of a tenant raising such an application in a county court set of proceedings for recovery based on a pay now, argue later argument. So those are my thoughts on it. I hope that helps.
Thank you, Peter. There's a question also on screen for Admas. This is from Marith McKellen about qualifying works, and she points out that there are figures of £250 and £100 used as trigger points for some of these obligations, which seem quite low in 2024, especially for small blocks. And she asks, are there any proposals to revise these numbers?
Yeah, that's a good question. I'm not aware of any. I haven't been through the bill. I haven't seen anything in the bill, but I'm not aware of any.
There are powers in the legislation for the Secretary of State to do so by regulation, but I don't think they have done since the legislation came in, which is why they are quite out of date.
Yes, I mean, I've got a sort of question or remark, which is that a lot of what we've heard about seems to be driven by this sort of populist legislation, which generates enormous, potentially, volumes of expensive litigation, not only for landlords who may or may not be well resourced, but also for tenants who may or may not be resourced. I'm interested, and this is really for the whole panel. Are you aware of any evidence-based analysis of whether any of this effort and expense is proportionate to any advantage that could be achieved compared with adopting a code of practice and allowing compliance with the code to count as a question arising in the question of whether any amount of service charge was reasonable? Has there been any sort of analysis of that sort of elemental question? You're aware of?
Not aware of any.
Not that I'm aware of. In relation to administration charges, I think that there is now proposed in the bill that landlords will have to set out a schedule in advance of what charges they're going to demand as administration charges in order to be able to recover them. I don't know where that's got to in terms of amendments, but not that it wouldn't relate to variable service charges.
It just sounds to me like more of the same, just layering further and further controls on an area that's already, some may say, regulated beyond the point of diminishing returns. Anyway, that's just perhaps a rather slanted question before we come to the next, which is from Mark Timberlake, also online, who, this is a question for Kim, I think. He points out that the FTT usually requires submissions under section 20C to be made before they make their decision. That sounds classically coherent for the FTT. How should we deal with that, given that at that stage, of course, you don't know their findings?
So I often advise that the application is made, but that the grounds for it will be expanded upon by submission after the decision comes in. And I normally say that to the tribunal at the hearing, that I will make submissions in relation to the section 20C application as and when we get the decision from the tribunal, assuming that the tribunal is happy with that. And they normally give you an opportunity to do so then in writing after their decision is given. But again, it's always worth flagging it at the hearing to make sure you don't miss the opportunity to do so, making sure you get just the form of the application in and that the tribunal is aware that that is coming down the line, even if the detailed grounds come later on.
Are there any questions from people in the room?
If the FTT strikes out application for one part, is it permitted to start the whole thing again? Or is that for all time?
If they strike it out for front of time,
For failure to comply with the time.
but I think you would struggle to bring it again, because there would then be an opportunity to apply to strike it out on the basis that it covers the abusive process provision that I talked about, that it covers the same issues that should have been covered in those proceedings.
It's absolutely crucial to observe that.
Yes, I mean it's not always the case that the tribunal will direct that things will be struck out if not complied with. But if that is in your directions, then it's as crucial. It should be taken as seriously as you would in a court, in other court proceedings.
Right. Well, thank you very much.